Worse, should the courts find that withholding full pay is illegal, the state will be liable for liquidated damages to twice the amount and could be ordered to pay interest on the amount illegally withheld. Finally, there will be a negative impact on the families that work for us, and that impact will further hurt our fragile economy. Aside from the expense of costly and lengthy litigation over my authority to pay state workers their full wages, his move would harm thousands of families who already are struggling with mortgages, higher gas, food, and energy costs. The loss of their spending dollars will increase the loss in consumer confidence and further deteriorate the California's economy. The Sacramento Bee reported that the governor's needless move to defer the pay to an estimated 112,500 state workers in this region would cost the area $15 million a day. The governor's proposal may plunge the state into an even more difficult fiscal situation. Now, just the rumor that the governor was considering this costly executive order was enough to disrupt the lives of state employees. Last week, an employee from the Department of Justice told my office that in order for her to be able to purchase the home she wanted, her bank had requested written proof that she would make more than minimum wage this month. Luckily for her, her supportive supervisors intervened and she closed on her home on Thursday. To work hard every day and have your finances held hostage is deplorable. I will continue to urge the governor to work with the legislature to pass a budget and to work with my office to ensure we have the funds to pay for all our financial obligations. But I will not play a role in penalizing public servants who have nothing to do with this budget impasse. It is important to remember that one of the main purposes of the Fair Labor Standards Act in creating a minimum wage was to protect vulnerable employees from employer wage exploitation. That is why Congress set a minimum salary level for all employees covered by the Act. And it is important to understand that the FLSA does not in any way prevent an employer from paying more than the minimum wage. In fact, the governor's order to pay California state workers only the federal minimum wage would put the state in an awkward position of violating its own labor laws. As you well know, Senator Flores, since January 1st, 2008, California law has required all California employers to pay their workers at least the $8 minimum wage set by the legislature. In this case, federal law does not trump state law. The Federal Labor Standards Act specifically states that no provision of this act or any other order shall excuse noncompliance with any federal or state law or municipal ordinance establishing a minimum wage that is higher than the minimum wage established under the FLSA. In other words, the FLSA recognizes that state law may provide employees greater protection than federal law. California's appellate courts have also ruled that the federal law does not control unless it is more beneficial to employees than the state law. One final point I would like to make. I want to publicly state how offended I am by the comments made by the governor's economic advisor, David Crane. In a piece published last week, Mr. Crane tried to justify the governor's cruel executive order by stating, and I quote, "A dollar devoted today to a non-essential expenditure is a dollar that in a month or two could be used for essential public safety. I do not see salaries earned by our hardworking public servants as non-essential expenditures, and frankly, neither do the courts." In a ruling handed down in 1948, the California Appellate Court noted that it has long been recognized that wages are not ordinary debt, that they may be preferred over other claims, and that because of the economic position of the average worker, and in particular his dependence on wages for the necessities of life for himself and his family, it is essential to the public welfare that he receives his pay when it is due. I have with me from my office Chief Operating Officer Michael Carter, Personnel Payroll Services Division Chief Don Shetman, and my Chief Legal Counsel Rick Chavarro. We also have Tim Schaefer, President of Fieldman Rolap, who is the financial advisor for our external borrowing team. They will provide more information and answer any questions that you may have. Thank you. And Senator McCloud, it's great to see you.
I just have to say, I'm so proud of you. You're John Chiang, and I'm Pat Wiggins, and I'm just so pleased with what you're doing. So thank you.
Thank you, Senator.
Okay, I was going to introduce Senator Wiggins as well. Thank you, Senator Wiggins, for being here. And, of course, Senator Gloria Negrete-McLeod, and your team can come up. Just a few questions. I know that also Senator Denham has a question, but let me ask just a fundamental question, if I could. Let's talk about the cash crisis. I mean, at the end of the day, this is the rationale for the executive order. And I'd like to go through that again, just a bit slower, if I could, just on the cash crisis. From your opinion, Mr. Controller, are we in a cash crisis?
We are not in a cash crisis. As has been articulated and publicly disclosed on our website, we entered into this fiscal year with $12 billion available in internal borrowing.
Right.
We have sufficient funds to make payment on all state obligations through September and perhaps even into October. The need for this, in light of the discussion about the cash crisis, I think is misdirected.
Okay. And the other question I'd have is that if we were to have a budget by midnight tonight, and I hope that's what Senator Prada and Senator Denham were talking about a moment ago. But if we were to have a budget by midnight tonight, would we still, in essence, be at a point where we'd have to go out to borrow in the markets, even with a budget in place by tonight?
There are two types of borrowing. There's revenue anticipation notes and revenue anticipation warrants. For the last 24 out of 25 years, we've gone out for revenue anticipation notes. So certainly it is tradition in this course to go out for a type of borrowing.
Right. So I guess my thinking, I read the same article by the governor's office, Mr. Crane, about their explanation of RANs versus RAWs and some of these other financial instruments. But I think there's a feeling that somehow we're doing this in order to avoid or to not incur the heavy penalty of going out to the market to borrow in order to do this. So I think either way, if there's a budget tonight, we're still going to go out to the market, most likely, in order to, it just depends what instrument, correct? A warrant or a note.
That's correct. There are different costs associated with those borrowings. However, if the governor was doing this, as he indicated, for cash purposes, he ought to articulated a plan and a path by which we wouldn't go out for that borrowing. And that is the follow-up that has not been provided.
Right. Is it fair to say that the layoffs, the terminations proposed in the governor's executive order, is that going to have any sort of meaningful impact on our cash situation from your vantage point?
No.
Okay. How about deferring wages? Is that going to have some sort of meaningful impact on our cash situation?
I think it would just make us look worse on Wall Street.
And you mentioned Wall Street for a moment. I'd like to explore that just a bit. What, from your vantage point, or even some of the financial advisors looking in the governor's, I mean, what is the feeling probably in Wall Street if people are looking at a battle between you, the controller, and the governor? I mean, this seems to be, if I'm picking up the Wall Street Journal or any other publication, is this giving the market any more confidence that we actually know what we're doing? That we're actually, to me, it seems as though we're some sort of state of confusion. People are wondering who's laid off, who isn't. People are asking the question whether or not you have the power, whether the governor has the power. We have legal scholars here today to tell us that you're absolutely correct. And these are two independent folks that I think are important to discuss this matter with it. Tell me about the perception from the market's vantage point of what the governor has created with this particular executive order from your perspective.
Senator, for a background perspective, we are the second lowest credit-rated state in the United States of America, only ahead of Louisiana. This only encourages Wall Street to look upon California. Some of them are reevaluating their standards to move to a standard of financial management, and I think this would lend to the argument that California is in financial disarray. They would ask why we chose this path without sound reasoning to pursue this pathway.
And have you ever, obviously, and most of the folks with you as well, being very intimately involved with California state government, I guess my thought is, has the governor ever taken a path like this? I mean, I guess I go back and I look at from Duke Majan all the way through, even when I was a staffer here. I've never seen a governor, in essence, put the burden on a state worker for the borrowing costs, the interest costs. I mean, it always seemed that government used to say, when we have to borrow, we don't like to borrow, we try to get our best deal with the market, but at the end of the day, we've got to pay expenses, the governor has said, and I think you hit it very clearly. Does the governor not see payroll, wages as an expense? That seems what he seems to be saying, that we have to do this in order to pay expenses. And I'm just wondering, from your vantage point, I mean, it seems to be this ought to be the very first expense, wages.